in which the judgment is written, my lord, makes an interesting reading. The basic problem, my lord, somewhere, my lord, right hand side column, second paragraph from the bottom, my lord, your lordship gets the basic problem. 1670, my lords. Right hand side column, second para from bottom. 1670, my lords. The basic problem, your lordship. The basic problem, your lordship. My lord Justice Padiwala. It's very interesting, my lord. I have read it fully, but your lordships may read it at leisure. The basic problem in all arbitration cases could probably best be explained not in terms of legal characterization such as condition precedent, ousting courts of their jurisdiction, or revocability, but rather by a hypothetical case in the tradition of ancient fabulist Aesop. Let us assume for a minute that for some reason all rabbits and all the foxes decide to enter into a contract for mutual security, one provision of which were that the dispute arising out of the contract would be arbitrated by a panel of foxes. Somehow, that shocks our conscience and it doesn't help the rabbits very much either. Now, what happens if we have the same contract with the same arbitration provision, except that disputes will be arbitrated by a panel of wolves? Is there such a community of interest among foxes and wolves that the wolves cannot be impartial? Possibly. Now, what happens if the dispute will be resolved by a panel composed by one squirrel, one elephant, and one wolf? One might conclude that squirrels look like rabbits, wolf look like foxes, and elephant ought to surely be, etc., etc. But eventually it says that elephant will surely be impartial. Then animal law becomes procedurally very complex. I'm not reading it, but it ultimately reaches a conclusion that this unilateral in the way in which we use it is not illegal. Go to. Lord, please come to Lord, last 2 points, and I know your lordships are looking at the watch.
You are just on something just.
Otherwise, I can ensure your lordship.
Over a long day of work, we have to have some pleasantries also.
I understand, but so long as your lordships are looking at the watch, there is no difficulty. I promise my lords will not be required to look at the calendar.
But here, the example, the rabbits will jump and the fox will trot.
An elephant is treated to be a neutral, obviously, because he doesn't look like either of them. Squirrels resemble rabbits and foxes resemble wolves.
Canine justice.
Yes, your lordships are right. That's the word. But 65. Kindly come to page 65. My Lord Justice Narasimha, my Lord, this question.
Written submissions, no?
Yes, my Lord. My written submission 65, part 5. Asymmetrical arbitration agreements in different jurisdictions. But first, two, my lord, in global context and present context, my lord, would be relevant because globally it has different shades, my lord. Asymmetrical has different meanings, not the way, my lord, we understand it. First, global context. Lord, kindly come to the table directly, my lords. Please come to page 65. There is a table given. My lords have.
Yes.
Lord, the purpose is to show that whichever country wanted to expressly prohibit one party to provide for a panel, it is so prohibited statutorily. And there is an exception made to the autonomy, party autonomy. Lord, Netherlands, for example, your lordships may kindly Lord, remember the color scheme, Lord, the legend. Green is permissible and the other color is impermissible. Lord, kindly see the underlined portion. This is, my lord, the statute in Netherlands, Dutch Code of Civil Procedure. Your lordship gets, my lord, that page.
Yes.
If the, my lord, I'll read, my lord. My lords are taking.
Yes.
Page 65, my lord, Netherlands, the statutory prohibition. We don't have, my lord, I'm not repeating. If the arbitration agreement, I'm reading the underlined part, this is the statutory language. If the arbitration agreement gives one of the parties a privileged position with regard to the appointment of the arbitrator or arbitrators, the other party may, despite the method of appointment laid down in that agreement, request the provisional relief judge of the district court within 1 month after commencement of the arbitration to appoint the arbitrator or arbitrators. So the law does not permit, or rather leaves it open for the other side to not agree, even if agreement is providing. Next is Germany. Similar, my lord, I'll not read it. Same, my lord, it is same. Page 66. Third is Spain. Spain, my lord, page 66.
Yes.
Article 15.2 of Spanish Arbitration Act. Please see 2, subsection 2. The parties are able to freely agree on the procedure for the appointment of the arbitrators, provided that there is no violation of principle of equal treatment. In the absence of any agreement, the following rules shall apply. But my learned friend wants to read 18, which is an equal treatment by the arbitrator in 11.2. This is how 11.2 could have been if the legislature so intended. I hope, Lord, I am able to make myself clear. 11.2 would have been in this manner if they wanted 18 and 11 to be read together. Then your lordships may, my lord, come to page 67, again Spanish, my lord, subsection 6. Not necessary. Lord, kindly come to 68. Estonia, my lord, section 721.2 of Estonia Code of Civil Procedure, Lord, para 2. A subsection. Arbitral agreement gives one of the parties in the formation of an arbitral tribunal an economic or other advantage over the other party, which is materially damaging to the other party. Such party may request that the court appoint one arbitrator or several arbitrators differently from the appointment which already took place or from the rules of appointment agreed.
No, the unamended provision is in footnote 2 at the bottom.
Yes, my lord.
The Chief Justice of India, the person or institution
Possibly.
designated.
Now
by
what
him
happens if the
in appointing
dispute
an
will be
arbitrator
resolved by a
shall have
panel
due regard
composed
to
by one squirrel, one
both the
elephant,
qualification
and
and
one
reason.
wolf?
Other
One might
considerations
conclude
may
that
also
squirrels
secure
look
the
like
appointment
rabbits,
of an
wolf
independent
look like
and
foxes,
impartial
an
judge.
elephant ought to surely be,
Therefore, there are
etc., etc. My
also
lord,
very
eventually it
few-
says that elephant will surely be impartial. Then animal law becomes procedurally very complex. My lord, I'm not reading it, my lord, but it ultimately reaches a conclusion that this unilateral in the way in which we use it is not illegal. Go to. Lord, please come to, my lord, last 2 points, and my lord, I know your lordships are looking at the
No, no,
watch, my
you
lord.
are just on something just.
Otherwise, I can ensure your lordship.
Over a long day of work, we have to have some pleasantries also.
I understand, my lord. But so long as your lordships are looking at the watch, there is no difficulty. I promise my lords will not be required to look at the calendar.
But here, the example, the rabbits will jump and the fox will trot.
An elephant is treated to be a neutral, obviously, because he doesn't look like either of them. Squirrels resemble rabbits and foxes resemble wolves.
Canine justice.
Yes, your lordships are right. Well, that's the word. But 65, kindly come to page 65. My Lord Justice Narasimha, my Lord,
Of
this
the
question.
written submissions, no?
Yes, my Lord. My written submission 65, part 5. Asymmetric has different meanings. Not the way, my Lord, we understand it. Lord, first, global context. Lord, kindly come to the table directly, my lords. Lord, please come to page 65. Lord, there is a table given. My lords have.
Yes.
Lord, the purpose is to show that whichever country wanted to expressly prohibit one party to provide for a panel, then it is so prohibited statutorily. And there is an exception made. This is my last point, Lord. I can assure party autonomy. Lord, Netherlands, when, for example, your lordships may kindly, Lord, remember the color scheme, Lord, the legend. a person is approached in connection with his possible appointment as an arbitrator, not a,
So making is what we are saying.
Lord, what has happened is,
The spot has being responsible. Because specifically a 43D, we have provided the duties of the council, which will be to formulate timelines, to formulate accreditation, to call for information, how many arbitrations are pending before each. Put it up, all that on the website. Everybody will know how many arbitration each arbitrator holds. What is the timelines? These are the requirements. Now, all of these are ad hoc arbitrations. So even assuming that they are ad hoc, some institutionalization or some kind of a regulation must happen.
Lord,
That was the purpose and object of the council.
I always say,
What your concerns are reflected here under 43D, subsection 2 to
Correct.
K, L.
but my Lord, B, 12A, 1B also says within 1 year. And there is thereafter 6 months extension,
Morning.
but 29A, my Lord, I only on the lighter side say, my Lord, before arbitrators, that arbitrators are now comparable. And it is on the lighter side, but nothing derogatory, with film stars in 2 ways. We always listen that we couldn't get the dates of this particular stars, therefore we have to appoint. My Lord, it's very difficult to get dates. My learned friend would agree. Very difficult. Today's date will go after 3 months, 4 months. And second, film stars operate in 3 shifts. So do arbitrators. Morning shift, afternoon shift, and night shift. It's good, Manu. There's nothing wrong about it.
Did you say
But
3 shifts or 3 screens?
Manu, that is Manu.
Just,
I bow down. I bow down, Manu. I could say only 3 shifts, Manu.
I was not saying anything.
He was just wondering whether he heard screens or shifts.
Well, the lawyers do that, my lord, that I can vouch for, my lord, we have been witnesses. Lawyers are hearing from more than one screen.
Unless we shift into this
Neutral
now,
arbitration.
ad hoc arbitration is an unorganized sector.
It is.
It's an unorganized sector, there is no regulation.
Whenever, my lord,
So unless we shift into a situation of.
institutional arbitration, this factor is considered. For example, Sarod, my lord, we have a Sarod arbitration. It is considered that this learned arbitrator has more than what can be done within 1.5 years. For 12 months, 6 months extension, but thereafter we survive on 29A. Court keeps on extending. And that's my lord, the hard reality, my lord, the ground reality. And my lord,
Why didn't you notify the provision and bring that into existence as an institution?
12(1)B says, my lord, that he has to disclose.
Answering that question with the
Why
Chief
is
Justice
the
asking.
government not notifying?
What's the concern?
Can be, my lord. I'll, my lord, consult the government and, my lord, it can be, should be notified.
Notify it immediately.
Certainly.
And you passed an act, right, for the other one? What is that act called?
That's part of this amended and included in this very chapter.
My lord, but,
Headed by Justice Hemant Gupta.
my lord, would it still, my lord, I'm posing a question to myself, dilute 12(1)B, that you have to complete by 12 months, you have to disclose whether you will be able to complete within 12 months, and extendable period by consent is only 6 months. I leave it at that. Well, so far as, my lord, NBFCs are concerned, well, last point.
Mr. Solicitor, what we have done is my learned two judges, brothers, Justice Pardiwal and Justice Mishra, we must have appointed, I think, about 25, 30 young lawyers as arbitrators in this.
That's a better way. My lord, that's,
in the
but
smaller
otherwise,
claims
my lord,
of-
I
not necessarily smaller claims, but
no, certainly, my lord, my learned friend, my lord, but my lord, your lordship.
that's the Bombay High Court in winding up matters.
Yes.
Ultimately, it's not about winding up a company, small claims. By consent, we would appoint arbitrators and not retired judges, we would appoint young lawyers, juniors at the bar who
Yes,
would
yes,
be
and
appointed.
they are doing it very enthusiastically and within the time. But, my lord, I flagged it, my lord. I don't wish to be more unpopular on this argument, my lord. Therefore, I leave it at that. But 12(1)B is a mandate and there is no consequence of non-compliance with that mandate. My lord, so far as NBFCs are concerned, but there are certain institutions like railways, non-banking financial companies, where they deal with thousands of cases, thousands of arbitrations. They will, by the very nature of their function, when I enter into an agreement for taking loan of say 2 lakhs or 3 lakhs, I know that there is a different bargaining power. They are taking a greater risk. Something which I cannot borrow from the bank is being borrowed from NBFCs. So I agree to a particular arbitrator. Otherwise, also, my lord, take for example a person who has taken a loan of 3 lakhs. My lord, I'm posing a question to myself: do we really expect him to go in search of an arbitrator? He finds an arbitrator who is ready to work as per Schedule 4 fees, etc., and my lord, deal with the NBFC.
Most of the smaller claims proceed ex parte actually.
Yes, but
They're typically
but
the lawyers appointed
to
by the
that,
bank.
my lord, there is a solution I am suggesting.
Credit card.
My lord, I have a solution, my lord, which I have placed on record. My lord, there is a solution on record. My lord, there is a, my lord, page SAMA, my lord, it is called SAMA. One example, there is one example. There is an institution which does online dispute resolution. That's the best thing, my lord, for small, my lord. SAMA stands for समझो मगर प्यार से. That's समझाओ मगर प्यार से. That's, forget the name, my lord. They could have chosen a better name. It's called SAMA, and my lord, this is at page 1983, volume 5A. Lord, please come to only for a second. Lord, this may perhaps be a game changer. Kindly come to page 2000, my lord, volume 5A.
Correct. We go on.
Only a minute, my lord. This may be a game changer. Your lordship would
Yes.
really contribute something, my lord, would be able to contribute something. Page 2000. My lord, this is one organization. Volume 5A, page 2000. It is recognized by the High Court, Government of Maharashtra, Bombay, Ministry of Justice, Union of India, etc. My lord, its advisory council is former Chief Justice, Justice Sri Krishna, Justice Kannan, etc., etc. My lord, this is online dispute resolution for small people. And the award comes within 45 days. Not expensive, no major, my lord, delays. I have placed, my lord, on record their entire activity. And this is recognized by many. Many banks have joined this for their small depositors or small problems. The loan agreements of smaller loanees, my lord, have a provision that dispute will be resolved by this. My lord, this, I think, is the solution for smaller depositors. We are not on big sharks, my lord, that's all. Obliged to, Lord. I'm grateful, my lord. I exceeded my time, my lord, but I'm grateful.
Yes, that's right. Now we go to Mr. K. M. Natraj. Yes, Mr. Natraj. Over and above what the solicitors argued, now what is the point that you are making?
Volume 5C, morning I forwarded my short written argument. So both on behalf of the court, that is the petitioner in the main matter which has been referred to the Honorable Court, and also I am representing IAC, that is Indian International Arbitration Center, which is an intervener. Representing both in the matter.
So what is the substance of it?
Yes.
You can just summarize.
Yes. May I kindly have my short written note, which is at volume 5C.
Yes.
So reflecting on the screen. I'll try to finish as early as possible without repeating any of the points which has been raised by learned solicitor.
Can you tell us,
Yeah,
I mean,
the-
just
yes.
formulate what is
Yes,
not.
the first one
not
is
argued.
the party autonomy, which is the basic feature of the
That Mr.
arbitration,
Solicitor
which for a different purpose I'm putting it, for the purpose of analyzing the very reference and the issue, which is the basic feature of the arbitration proceedings.
Your second bullet point is correct, that
Yes,
7.6 arises
yes.
only if any of the situations provided in A to
Correct.
C are not
Yes.
fulfilled.
Secondly, there is no statutory bar on either of the parties, either independently or jointly appointing an arbitrator. There is no statutory bar. Either of the parties can independently, one party can appoint an arbitrator, or jointly by virtue of some kind of agreement, jointly they can appoint. That is recognized and ingrained in section 11(2) of the Act, which is party autonomy.
Yes.
If that is the case, when there is a statutory bar, party autonomy has to be respected, and which is further fortified by section 11(6). Kindly take section 11(6), which again speaks of the agreed procedure.
What's the submission, Mr.?
Yes, under 11(6), it further fortifies the party autonomy for appointment to evolve any kind of procedure to be adopted by the parties, either individually or independently. And again, section 12 also recognizes and fortifies such a right.
Yes.
By keeping in mind, two things will have to be considered. One is both appointing authority or appointing person and the arbitrator are two independent and distinct entities, and their identity is different. Appointing and acting are two distinct roles.
All right. Next, what is the next point?
They are distinct roles. If they are distinct roles, the statutory prohibition is only for the purpose of the acting as an arbitrator, not for the purpose of appointing. The law does not prohibit any kind of restriction insofar as appointing authority is concerned.
Yes. Next.
The appointing authority can appoint, and the impartiality or the neutralities that is attributable only to the arbitrator appointed and acting as an arbitrator.
All right. What is the next point?
If that is so, now what is not provided under the statute that need not be read into,
No limitation.
no limitation
Yes.
prescribed under the Act.
No limitation can be written by implicit.
Yes. And the omissions, even if it is an omission, that cannot be supplied by interpretation.
All right. Anything else?
These are in support of that 4 judgments I have also placed, including the wisdom of the legislature, upon which once there is no embargo on the person who can appoint, then there is nothing more to be said about it. And 2 things: in TRF, the situation was totally different. TRF, that the arbitrator himself was the managing director himself was an arbitrator, and also he was supposed to appoint. In that context, it was said so in the TRF case. And here in the second, this reference by Justice Nariman and the 3 judges bench in Tantia, kindly see that reference itself is totally may not be appropriate. This one reference, kindly see how it has been referred in this one in volume 1, page number 3. It presupposes something which is not otherwise provided under the Act. Kindly have a reference at page number 3.
Volume 1, page 3.
Yes. eligibility, everything is on the arbitrators, not on the appointing authority. So therefore, there is nothing to read something relatable to the appointing authority. I'll leave it, please.
Nataraj. Now we will hear Mr. Arvind Kamath.
All right.
Mr. Kamath, apart from what has been argued, what would you like to say?
Yes, my lord, I represent the BMRCL, which is the Bangalore Metro Rail Corporation. Now, I'm purely on the issue of the maintenance of the panel system. Now, I've got
The maintenance of?
maintenance of the panel by one party,
Right.
purely on that issue. Lord, I've got 5 propositions stroke principles to be placed before
Just
Lordship.
tell us, formulate.
And Lord, the first one is that the contractual conferment of a right to form a panel of arbitrators is a commercial bargain.
1 second. Hold on, that's
But I'm saying the contractual confirmation of a right to form a panel of arbitrators is a commercial bargain, and it falls within the purview of party autonomy under section 11(2) of the Arbitration and Conciliation Act. Lord, every commercial contract is a result of a commercial bargain. Lord, parties are free to bargain their rights, provided it is consistent with law and public policy.
the point. Second, what is the second point?
The second point, my lord, is that enlisting of the names on a panel does not per se constitute appointment. Lord, I enlist the names only for the purpose of administrative exercise. My lord, merely because I add the names on the list of potential arbitrators, there is no conferment of any rights, nor does it entail any remuneration. It does not even guarantee a right to be appointed.
That's
No,
the
it-
second.
it-
Got the point.
It is
Third-
only
third
obtaining
point.
prior consent.
Third point, Mr.
My lord, the third point would be that, my lord, yesterday we saw the perception-based challenge to the procedure of appointment is not sustainable in law.
1 second.
Lord, every strand of argument
Just 1 second. Perception-based challenge.
to the procedure of appointment of arbitrators from a panel maintained by one party is not sustainable.
Panel.
Lord,
One
perception,
second, 1 second. From a panel maintained by one party. By one party, what? Is not sustainable.
is not sustainable. My lord, yesterday we saw, my lord, argument like, for instance, there is a economic incentive to pass an award in favor of the party who maintains. My lord, it is based on perception. My lord, the allegation that I curate a list, my lord, is based on perception.
Fair enough. What is the fourth point?
Lord, the fourth point would be that there are statutory safeguards to ensure independence and impartiality of the impaneled arbitrators. And it's a 4-tier, the statute has laid down a 4-tier mechanism. And those 4 are, Lord, I'll quickly enlist the 4. Lord, number 1 is the insertion of section 12(5) as well as schedule 5 and 7.
Yes.
Lord, number 2 is the mandatory declaration, Lord, which is a consentious declaration. It is akin to an oath by a judge.
Mandatory disclosure.
Mandatory disclosure under
Okay.
section 12.
Third,
Lord, the third is, Lord, the statute provides a challenge. Just in case, Lord, an unconscientious decision is made by the arbitrator, it gives a right to the party to challenge him.
okay, that's the
And Lord, fourth is that if there is a challenge made and if it is declined, that gives a ground to challenge the arbitral award. So which means there is a judicial review of the decision of the arbitrator that there is no bias.
yeah.
And both those arbitrators appoint the presiding arbitrator. So which means it's a very fair principle.
Thank you.
Therefore, not I'm breaking down, Lord, the formation of the panel should be divested from the way the panel operates. The formation of the panel, my lord, it's a contractual right. But how the panel operates, my lord, Voestalpine has laid down the principles. So therefore, not to summarize, maintenance of a panel by one party is not following on the sole ground that Tantia doubted core. Not the learned single judge should not have, learned single judge should have followed core.
Well, thank you.
I'm grateful.
You've rendered very valuable assistance, very well formulated.
I'm grateful,
Thank
Raj. I'm
you,
grateful.
Astra. Yes, now, 1 second. Now, we will, Mr. Guru Krishna Kumar.
I'm in 501.4, my lord.
Yes, Guru. What's the formulation?
My lords, broadly, four points, my lords. In fact, my submissions, I'll put it as propositions and leave it at that, my lords.
Number one.
One, while adopting, my lords, the submission on behalf of the Solicitor, by the Solicitor General, my lords, that the statute per se does not bar unilateral appointment of arbitrators. I adopt that. While adopting that, I want to make this formulation. The exercise of power under section 11(2) of the Act, my lords,
1 second.
is conditioned by section 12 of the Act. Because the language used in 12 is anybody invested with the authority to appoint before the appointment has to get declaration from the prospective candidate. Which means, therefore, my lords, please see the language for a minute, my lords. Just have a look at that. Please see 12. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances, then A, B, etc. Then please see the second explanation to 12, my lords. 12 after B. The disclosure shall be made by such person in the form specified in the 6th schedule.
All right.
So this is one. Therefore, bodily, my lords, 12 and Schedule 5 and Schedule 7 have to be read into 11(2). That's one, my lords.
Yes.
Second point, my lords. Mutuality, which seems to be the premise on which, my lords, there is reliance on 18. There are three.
Mutuality.
Mutuality is the premise on which, my lords, section 18 is being invoked and sought to be read into the appointment process. Now, for that, I have three submissions, my lords. Number one, that does not take note of the fact that 18 is a general provision in the next chapter, whereas 11 is a provision specifically for appointment. And the legislature has consciously, my lords, not brought in that principle in 11.
Next.
Third point, my lord, assuming 18 can be invoked by some basis, mutuality will have to be understood, my lords, in the business setting and the fact setting of the parties' transactions. Arbitration, my lords, is at the end of the day a consensual arrangement for adjudication of disputes other than through the court process. Therefore, the business setting and the background of the transactions will have to be understood. There cannot be an omnibus stand that unilateral appointments cannot be resorted to at all. And to contextualize this submission, my lords, I want to talk about my NBFCs. The Solicitor General referred to it in the passing. I am representing an NBFC. I have a claim for a few lakhs of rupees. In fact, in this very case,
Yes.
the party does not respond to the notice for appointment. I go ahead, appoint the arbitrator, award is granted. The award is sought to be executed by me. At that stage, Perkins is taken note of by the execution by court by itself, and, my lords, the award is held to be a nullity and the whole thing is set aside. I've come against that, my lords.
All right.
Now, therefore, this is the second point, my lords. Business setting has to be understood. In fact, the fact that business setting is a factor in the legislation, please.
All right,
make a
now
note.
1 minute, huh?
Uh,
You have
one-
to- Yes, you have to complete the.
There,
other.
my lords,
Next.
the next point is, my lords, the nature of, my lords, the transaction and business setting, it is given importance, my lords, in the statute itself. For that, just please make a note of explanation 2, schedule 7 and 5. Just have a look at that. Please see explanation 3. I'll just read that, my lords. For the removal of doubts, it is clarified that it may be the practice in certain kinds of arbitration, such as maritime or commodities arbitration, to draw arbitrators from a small specialized pool. Now, one thing,
Where do you
I'm
read
reading
Schedule 5?
from the explanation, my lords, to schedule 7, and it's there in schedule 5 also.
Schedules explanation.
Yeah, schedules explanation. Both schedule 5 and schedule 7, my lord. Explanation 3 in both.
Practice in certain specific maritime or commodity.
Yeah, such as maritime, and therefore, the nature of the business setting, my lords, becomes material, even statutorily recognized.
Right.
The last point is this, my lords. What is the alternative, my lords, that they are talking about? The entirety of the submission is on a perceived apprehension of bias. The entirety of the submission, it's on a supposition that unilateral appointment necessarily is not fair. Law cannot countenance that. In fact, my lords, the alternative of institutional recourse. Number 1, my lords, lack of institutions. Number 2, metros versus non-metros, my lords, where is the access to institutions of that nature? We are looking at small loans across the spectrum, my lords, MSMEs, consumer durable loans, all of that. I have today, my lords, 6,000 arbitration awards in my favor. And I have 10,000 cases every month or something of that order. Third aspect, my lords, if we have to take recourse to court, please see the burden it will add to the court system.
Thank you.
These are the points, my lords.
Thank you. Thank you.
Yeah.
Now we'll hear Ms. Madhvi Devan.
One last thing, my lords, my apology, alternate submission. In case my lords were to countenance Perkins, please, my lords, look at prospective overruling. In case my lords are
I
concerned.
didn't address that, but that is going to be a very vexed question, my lord.
Yes.
Whichever way your lordship decides, whether it would have prospectivity or retrospectivity, because in some cases arbitrations are going on, some cases 34 is going on.
So many
cases
thousands of awards.
37 is going on. In fact, Mr. Shashank Garg wanted to, Lord, have few minutes, if your lordships can permit, my lord, on only prospectivity.
In fact,
Well,
That's an alternate submission.
that's an alternate submission. My submissions, my lords, in volume 5, I have covered that also, my lords. My lords can have a look at that, my lords. Page 277, my lords. My submissions are there, my lords. I'm deeply obliged.
Yes,
Yeah, that's it.
yes, Ms. Madhvi Devan.
Yes, my lords, I appear also for an NBFC and my issue is of unilateral appointment. My lord, the points I will make is 1, my lord, this is a very comprehensively crafted scheme by the legislature under 12, 13 and 14, which has been ignored by the court, my lords, in Perkins and even before that in TRF. And I'm going to, my lords, show your lordship the devastating impact of not taking into account this comprehensive scheme, which creates 2 categories of clouds on integrity, on independence and impartiality. There are 2 categories, and perhaps, my lord, this has not come up in the arguments this far. So I'm just spending, my lord, a couple of minutes on this. There are 2 categories. One is what is described as the non-negotiable category, which appears in 12.5, read with the 7th schedule. Other than, my lords, the proviso over there, it is an absolute bar of ineligibility. 7th schedule based on red list, best international practices, very intricately carved out bar of rank ineligibility at the very threshold. Now, when it comes to this rank threshold ineligibility, the effect is the arbitrator, my lord, the appointment is void at the threshold, there's cessation, and the procedure is that you go under 14.2 for termination and substitution. So it's a different procedure when in category 1, I'm describing it as category 1, threshold ineligibility under 7th schedule, resulting under 14.2 in termination and substitution. Now, my lords, mine is not a category. Unilateral appointment is definitely not barred there, definitely not. And therefore, applying the principle of, my lord, expressio unius, my lords, I won't get, but basically the expression of one means the exclusion of the other. My lord, this was all expressio unius, exclusio alterius. So that is the principle. And insofar as I'm concerned, my lords, please see, it doesn't fall within that. And these schedules, the two schedules that, and the other one I haven't yet referred to, the two schedules were brought in by this amendment in 2015. Before that, everything was left to a little bit of vagueness, but now that there is this schedule, you have to follow it. The court could not have added to this either in Perkins or in my lord TRF to start with. They could not have added to this, and they did not consider the devastating impact, which I'm going to point out, my lords, which it is having. Now, that is category 1. Category 2, my lords, shows that even, my lord, in cases like mine, if the other side is aggrieved, they have a remedy. They have a remedy. That category 2, my lords, falls into cases which are under the 5th schedule. So other than the non-negotiable variety under 12.5 7th schedule, you may also challenge if you feel there are justifiable reasons for challenging the appointment of the arbitrator, which may fall within 5th schedule. And mind you, my lords, I must point out, the 5th schedule is only a guide. The language of section, I mean, my lord, to save time, I'm not referring to it, but please note the word used, it's to serve as a guide. 5th schedule is a guide, but 7th schedule is exhaustive. So if you apply that, my lords, even a unilateral appointment, perhaps you can challenge, but it's not rank ineligibility at the threshold. That's the distinction I'm making, my lords. So what Perkins and TRF do is they knock them out at the threshold saying you are ineligible. That cannot work. That's not correct. What happens in the second category? I'm sorry. My lord, what happens in the second category of cases that if you are aggrieved by some justifiable ground, which may fall within Schedule 5, it may be a little bit beyond Schedule 5, but you may be guided by it. Then, my lord, the procedure is different. It falls under Section 13. You go before the arbitrator and challenge it. You go before the arbitrator, and if you are not successful, the award is passed by the arbitrator, and then you may challenge it on that ground inter alia under 34. And then the court decides whether he gets his fees or not, if you are successful. So, my lord, there are two different parallel things, two categories, different procedures which are prescribed with different consequences, but unilateral appointment may fall within the second category, but it certainly does not make my arbitrator ineligible. Now, the reality of our situation is that in
6, yeah.
My lord, the reality of our situation is our, my lord, other side does not, in 95% of the cases, doesn't even show up at the notice or the arbitration. So if he has the opportunity to challenge if he wishes to, saying that this is unilateral and it is therefore not impartial, etc., but he has not done so. So by the court in this case, my lord, and that's the impugned order, the court helping him out and setting aside the award effectively on the ground that this is violative of Perkins means what, my lord? Ultimately, it's a defaulter's paradise. It is giving him an incentive to walk away. He is not wanting to challenge it. He is not coming over there, and yet we are creating a situation of a defaulter's paradise. So, my lord, now please see, my lord, this my second point that I wish to make here is that both Perkins and TRF, my lords, are, with great respect, they are oblivious to not only this comprehensive scheme in the Act, which takes care of every eventuality, but also the specific SOR which accompanied the 2015 amendment, specific SOR, and the business realities of the situation. And when I say business realities, I don't only mean business prudence. I mean, my lords, today, for example, my lords, I have awards worth, my lords, 22,000 crores in excess. They are at the stage of execution. Some of those awards have been knocked out on the ground of Perkins. That is the devastating impact it is having when the other side has not even shown up to challenge it. Now, my lord, even though every year I, as Mahindra and Mahindra, I dole out, and my lord, this is for vehicle financing. So these are small people who get loans to get taxis, trucks, auto rickshaws, etc. So it's livelihoods. There is employment being generated and families are looked after through these livelihoods. What happens in the process is that, my lords, if my today 22,000 crores because of Perkins and the other judgment, my lord, TRF, I'm not able to execute those awards and they will be knocked out, as some of my awards have already been knocked out of the stage. What happens is this money is stuck in the economy. I'm not able to recover. I'm sorry?
Again, awards become bad. These are in
Because of Perkins, because, my lords, what they say, because of Perkins, these arbitrators are ineligible, unilateral appointments, because, my lords, please see, very interesting. I'm glad I'm grateful. Why? This is what has happened. Please see, my lords, in Perkins, that principle of TRF is taken.
Have been set aside on the ground of Perkins.
Yes, in my case, hundreds and hundreds of awards at the stage of
So
execution.
you appointed your arbitrator directly. What happened?
Well, we appointed, they never challenged, the other side.
No, most of them are all ex-party awards, is it?
Yeah, ex parte.
Actually, okay, you appointed an arbitrator
Yes.
on the basis of your panel, and he's proceeded to give an award. And those were set aside by the courts under 34 on the ground that it is hit by Perkins.
54, they never came. At the stage of, when I went to execute,
Whichever.
it was set
Yeah,
aside.
naturally.
But did you appoint your arbitrator under, by moving the court under 11, or you just unilaterally appoint?
Milord, no, that's my agreement. I appointed in accordance with my agreement, point number one.
So what you do is that you say, well, I'm appointing an arbitrator.
Milord, please see, it is, he is noticed, well, just 1 minute.
That doesn't matter. The principle, what we are concerned is the way we should interpret.
That's right. Whether a
the
preparation
panel.
of unilateral panel is-
Your cases are all standalone cases where at the time of execution, the courts have said the review of Perkins awards are set aside. So stand on a different footing.
Milord, unseat trial must have a limit. No, no. Not relevant. Milord, I am saying this, how can Perkins apply if I'm not in that red list? I'm
Company?
Mahindra and Mahindra, but there are many others.
Because there are 5 lakh
whom you appoint as arbitrators, buddy?
Advocates, all advocates. And nobody has said that they are Milord.
All right, this is
All
not
right.
so much.
See,
We'll not go into the individual
This is
sides. We
slightly
know what's
different
happening here, but
Milord, please see how either I fall within, Milord, 12.5, I have to fall within 12.5 and the 7th schedule. Where do I fall within that? I don't. That's my point.
You are on the basis point. We are only going to interpret.
Now, please see the practical reality, and because ultimately you're in NN Global, Shiv Shakti, my lords, all those judgments your lordships have said. So therefore, I'm saying they have an opportunity if they are unhappy, and we wrote to them saying we are appointing so and so. If you have an objection, please respond. They don't respond. They don't respond. And where do I go, my lords? Companies like us, we
But your arbitration agreements provide for a sole arbitrator to be appointed by you.
yes, they do. And there's no, it's not proscribed. and-
All right, we'll not go into this actually. This we need not go into. So essentially, the arbitration takes place by a sole arbitrator appointed by the financier.
See, what is the alternative? I go under section 11, just please consider, there is no
No,
provision.
you can't go under section 11
Exactly.
because that's a 11(2) procedure.
Large number of section 11s have been filed by finance companies, insurance companies after clearer. Independent arbitrators have been appointed by high courts. There is an ADRS Malad platform. The learned Solicitor General also provided another independent platform.
Malad,
The sort of.
There is
Not the-
Yeah, no, Miss Diwan, the point is only this. Can there be a unilateral clause by virtue of which, look, I will appoint an arbitrator. You may be I'm a finance company, I will appoint an arbitrator. I will appoint a lawyer who will be an arbitrator. The matter will proceed ex parte. And some poor taxi driver, truck driver, his truck will be dispossessed. Yeah. Poor truck drivers, he will be thrown out by a bunch of goons who will sort of catch him on a national highway, throw him out in the middle of the night, take his truck and say, we have the award for 20 lakhs against you. That's what's happening. That's the reality. That's the reality.
Mr. Paul, please allow.
That's the reality. Yeah, ठीक है. मैंने देखा.
No, my lords, please see this point. I cannot engage.
Don't take it to that extreme, it might be counterproductive to you, to your argument. So far as the interpretation of the larger principles, if we are thinking about it, that you make a submission, don't go into this devastating effect and all that is irrelevant. On the interpretation of your clause, say,
This
it's taken into the
is
account.
actually putting arbitration on its head. It's providing arbitration a bad name. You've dealt with n number of cases in the Bombay High Court, I can tell you, where, less said the better how it is done.
What is my alternative but to have, if he is not even coming, if he were to come and cooperate.
Can a poor taxi driver, a truck driver, a two-wheeler driver in Kolhapur or some other guy go and contest against Mahindra Mahindra? That's a hard reality.
56,000. Now, if we opt out, what is the option? We can't go through goons. We can't file a suit.
That's the kind of things they're doing. Each of those arbitrators, I didn't want to get into the merits of my learned friend. 400 arbitrations per week per arbitrator, so-called appointed independent arbitrators unilaterally.
How do I go ultimately? My lord, we are providing, banks will not entertain these taxi drivers. I am entertaining them. We are all providing loans to them and we are not doing favors. If we get back our money, we can finance more. We are providing a service. Lord, government's mantra is ease of doing business, provide employment. This is happening through us. How do we recover our money? We are giving money.
Sorry, but Perkins is a sole arbitrator case that may perhaps not arise. These issues, here your lordships are deciding whether a panel is permissible.
That's right.
Perkins was, my lord, that's, my lord, we generally forget, my lord, while citing, it was a sole arbitrator.
So, my lord, my case is also of a sole arbitrator, which is why I'm concerned. If I don't fall in the red list, if I don't fall in the 7th schedule, how can I be knocked out on the ground of eligibility?
Generally, if parties agree that there will be a sole arbitrator appointed by consent, the
Yes.
other side doesn't consent, you have to move the High Court under 11. High Court will ensure that a genuinely independent.
Not consented, he receives the.
Did you ask them for consent?
Yes, when I appoint the arbitrator, I ask him.
But there's
Under the execution.
We put all.
those matters will be dealt with independently.
Since I'm
Why do we have to go?
Because of Perkins, my lord. Your lordships, if your lordships are going to pronounce on, ultimately it will boil down to Perkins. Even in the panel matter, it will come to Perkins, who is incapacitated. Who is incapacitated, that it begs the. My lord,
My lord, then your lordships will consider detagging this matter because
my lord, I wrote to him, if you have any objection, please show me. Yes.
Lord,
Lord, sorry for
My
interjecting,
letter,
but
my lord, my letter to him asking if he is objecting is on record.
The issue, we are saying the power to appoint even the procedure. We are just ABS. Upper to a point.
My lord, I.
Lord, this NBFCs tend on a different footing. They have different fact situation, different arbitration clauses. They are not concerned with penal. Kindly detag it. My lord, it need not be dealt with by the constitution. bench.
Unfortunately,
And whatever judgment comes, my lord, whether they help them, whether they.
I'll tell you one thing, speaking for myself as single judge, division bench, I have seen what happens when unilateral appointments of arbitrators are done. Literally, you can
Lord,
hold,
Lord,
I'm not saying
Lord,
that.
we
I'm
have-
not
we
saying
have
that
done our
most
best, my lord.
defaulters-
It may
that the
not go in
defaulters
this.
are necessarily, but most of the defaulters are individuals, sole people, somebody's auto rickshaw, somebody.
Lord, Madhavi, can I say something? You already,
The procedure for arbitration, is perverted by this.
my lord, kindly deal, my lord, NBFC issues separately. My lord, your lordships are dealing with the scheme of the act.
No, we don't even
Permiss-
need to do that. We will answer this, the difference.
Lords, I'll tell you, Lordships, because I have
We
5
would
lakh
not like,
arbitration
Lord,
costs. There are
our
five-
larger issues to be, Lord, colored at the end by this, Lord. That's-
I represent a body, Lords, which
You
has
cannot
5
pick up
lakh.
those cases, you must challenge it.
Lords, so that's.
Challenge it.
my lord,
Partial.
That's it. That is those individual cases, we will see if you might succeed.
Lords, but 5 lakh arbitrations are, Lords, now under effect.
No power. Still, no. Done is one power because in
to appoint an arbitrator, how am I barred? Is a party barred? Is a party barred from appointing? There is no such bar in the very intricately crafted act and schedules.
All right, we will consider.
Please consider that, my lords, and ultimately, nobody is
Alright.
giving these people
Then,
notice.
Mr.
My
Anand
lord,
Padmanabhan.
I have my own submissions, my lord. I would not endorse any of these submissions, my lord, but, because they have a fact specific case, that's all.
Sir, may I put in a written note?
Mr. Anand Padmanabhan is there.
Lord, I'll take 3 minutes by the clock.
3 minutes. Then we have, after Anand Padmanabhan is the last for the petitioners. Then we have Mr. Jetmalani, then Mr. Napil Diwan, Dinesh, Munkund, Suman Doval, and Naresh Kaushik.
Because I have also, because I have also filed. Let's.
Well, but we'll assemble tomorrow at 2 o'clock because instead of. But we'll have to complete by 3, huh?
I think.
Not 2 to 4. But a miscellaneous day, I may have to go back to my regular bench. So we'll say 2 o'clock, we'll take this between 2 and 3, not beyond 3 o'clock. So
My lords,
No,
between us are 7 minutes each. my lords.
But I will do it in 5 minutes. I don't need more. than
That's
5.
all for us, my lords.
My lordship,
also, we'll just look at quickly the reference by Justice Nariman.
Yes, yes.
That one para order,
There
which
is-
really doubts 4.
Yes, that's doubt score and in JSW, because the Karnataka High Court relied on core. They refer it also to the Constitution bench.
Nobody's doubting.
Core was doubted in Tantia, and in JSW, there was a completely different clause. The High Court said, the MD in the case said, I'm appointing as per core, ignoring the arbitration clause. And the High Court says core is said so what's wrong with it?
Lordship, I had a small request to make, Lordship, I had a small request to make. Today in the alternate bench, item 1 is the jet insolvency matter. If it can kindly retain its position.
Constitution bench, how can you pass? on
My
to the-
apologies, my apologies.
But wait, I'll talk to the registrar. Don't worry.
Deeply obliged, Lordships, deeply obliged.
Chali.